Hello, good evening, and welcome to Unacademy, a one-stop destination for the English medium civil services aspirants. Welcome to Lecture 4 of Conquer Prelims. And you would know tomorrow is the last lecture on Indian polity of this series, Conquer Prelims. But tomorrow's lecture is going to be the most important one of all the 5 sessions. Why? Because tomorrow we will have a marathon session on Indian polity, and we will discuss some of the most important questions. And in total, we will be discussing more than 50 questions. So if you have missed all these classes, I would urge you not to miss tomorrow's class. It's going to be extremely helpful and hopefully relevant for the upcoming prelims examination. So don't miss tomorrow's lecture, but don't leave this lecture either, because we are going to discuss something very, very important for the upcoming exams. Let's get started. Question number 1 is on your screen. Which of the following statements regarding the Bharatiya Nyaya Sanhita, and this is, you would know, replacing the Indian Penal Code from July 1st, 2024. The age of criminal responsibility is 7 years. The Act punishes sexual intercourse of a man with his own wife who is living separately without her consent. The law adds community service as a form of punishment for petty offences. Select the correct code from below. You have 1 minute. Let me know what is the right answer. Priya has been consistently doing well in the series. Very good. And to tell you what is the right answer, see 3 statements. All the 3 statements are correct. Now let me elaborate. Indian Penal Code, which is getting replaced by this law, Bharatiya Nyaya Sanhita 2023, Indian Penal Code also talks about criminal responsibility. For example, who will be responsible for committing crimes? In a sense, if you commit a crime, you will be held accountable for that. Punishment will be imposed on you. But just like IPC, this Sanhita, this law also says that if you are less than 7 years, you are not responsible because you are immature. You don't know what you have done, what is the ramification of your action. So a child less than the age of 7 is not accountable, is not responsible for his criminal action. But if you are in the range of 7 to 12 years, you will be responsible provided you are of mature mindset. And what do we mean by mature mindset? That means you're aware of what you are doing, what is the crime that you're committing, and what would be the ramifications, what will be the consequences of your action. If you are of that mature mindset, even if you are in the age group of 7 to 12, you will be held responsible for your criminal actions. And then whoever is about 12 years of age, that individual is responsible, 100% responsible for the criminal actions. So when we say statement number 1, the age of criminal responsibility is 7 years, just like IPC, this statement is correct. Clear? Now listen to me carefully. You might have heard of marital rape, and it has been a long pending demand by feminists, by progressive men as well, that rape, wherever it happens, whether it is outside marriage or within the marriage, it should be criminalized. But the policy makers, the lawmakers are not in favor. Even if you have not given consent, but you are in a marital relationship, there is no rape. But this Sanhita, it does talk about that if there is an individual man who has committed sexual intercourse with his wife, who currently is living separately. They have pursued divorce. The divorce has not been formalized. This woman is living separately. You will be held accountable for that. But unfortunately, the punishment is up to 7 years. So anywhere in the range of 3 to 7 years, punishment can be imposed, which various experts have questioned. If the punishment for rape is a life imprisonment, and here the man is also committing the rape, why are you lowering the bar of criminal responsibility by saying that you will be punished within 3 to 7 years or for 3 to 7 years? But that is a subject matter of the upcoming mains examination. For the prelims examination, don't confuse it with the marital rape. Marital rape is not an offense, because in marriage, we assume there is always consent. The lawmakers have assumed. But this act punishes sexual intercourse of a man with his own wife who is living separately without her consent. This is clear. This is correct. The law adds community service as a form of punishment for petty offences. This is also correct. That is why 3 statements are correct. C is the right answer. Now, what is this community service? For example, you will be asked to do unpaid labour. For example, you will be asked to clean parks. For example, you will be asked to work or serve in the hospitals. And this is where we have to link it with another important current affairs topic. And what is that topic? Criminal defamation. Shri Rahul Gandhi was convicted for criminal defamation, sentenced to 2 years in jail, and that is how he lost his seat in Lok Sabha as well. Later on, that sentence was suspended and he got his Lok Sabha seat back. But what is the link here? This Bharatiya Nyaya Sanhita, it talks about criminal defamation as if it is a petty offense. And for this criminal defamation, you may be imposed with a community service. So that is something, that is the link that you will have to keep in mind. That makes it an important statement for your upcoming examination. So after 2024, July 2024, if Shri Rahul Gandhi again commits criminal defamation, maybe he will be asked to do community service instead of losing his Lok Sabha seat, provided he wins it. But something else. This law also punishes stalking. Another important statement. This law, what it also does, it decriminalizes attempt to suicide. For example, there used to be section 309 of Indian Penal Code which would criminalize attempt to suicide. If you commit suicide and it is successful, you are too dead to be held criminally responsible for your action because you're dead. But if it fails, you are a criminal in the eyes of the law. Although Mental Health Care Act of 2017, it talks about decriminalization of attempt to suicide, saying if you have attempted suicide, you will be treated as somebody who is mentally unsound, mentally sick, who needs care, who needs protection, who needs guidance, and you are not a criminal. And now what this Bharatiya Nyaya Sanhita does, it removes this offense from the list of Sanhita, from the law. So attempt to suicide is no longer a crime after July 2024. Something else. Have you heard of section 377? Whosoever voluntarily indulges in carnal intercourse, which is against the order of nature, that used to be a crime. But this section was used to criminalize homosexuality, adult consensual sexual relationship between people of same gender. That was struck down, or that was read down by the Supreme Court in the Navte Johar judgment. But it was this section 377 which was still invoked in cases of bestiality, sex with animals. Now, animal rights activists are confused. Why? Because now section 377 does not find a place in the Bharatiya Nyaya Sanhita. So there is no, I repeat, there is no express provision in this law which would criminalize bestiality. So now we are seeing instances of violence against animals It has increased over a period of time, and animal rights activists are concerned that in absence of something like Section 377 in the Bharatiya Nyaya Sanhita, there is no express provision to prosecute, to convict somebody who indulges in bestiality. So there is a grey area here. That's another thing that you have to keep in mind. But this Bharatiya Nyaya Sanhita, what it does, it excludes SLLs. Can anybody tell me what this SLL is? Anybody? Nobody? Special and local laws. Very important, can be asked in your upcoming prelims examination. What is a special law? A law which is applicable or which applies for a particular subject. Can you give me an example of this special law? And what is a local law? A law which applies to a particular location. For example, in Tamil Nadu, there is a ban, or should we say, there is prohibition on selling lottery tickets, which means this is a law which applies to a particular location. That's a local law. And then there is a special law, a law which applies for a particular subject, such as Unlawful Activities Prevention Act, such as MCOCA, Maharashtra Control of Organized Crime Act, such as POXO, Protection of Children from Sexual Offences Act. All these are specific for a particular subject. These are what we call special laws. But what this Bharatiya Nyaya Sanhita does, activists say, experts say, that although we have had a reform in Indian Penal Code, but we should have had a similar reform in the special and local laws as well. Because in 2022, 39.9% of all the cognizable offences were under special and local laws. And that is where there is variance in implementation as well. For example, in MCOCA, if you are giving a confession and that confession is recorded by the police, that is admissible in a court of law, which would violate normally Article 20 Clause 3, which says you should not become a witness in your own case. But there are some special laws, for example, MCOCA, where if you give confession before the police, which is recorded by the police, it becomes admissible in a court of law. Similarly, under UAPA, similarly under Prevention of Money Laundering Act, these are all special laws. So we need reform in the special laws as well. So if the statement is asked in the examination that this reform, Bharatiya Nyaya Sanhita, which replaces Indian Penal Code, it does not touch the special and local laws, that statement would become correct. Is that clear? Okay, done. Let's look at question number 2. Which of the following statements is or are correct? Both the central and the state government has the power to issue directions for interception, monitoring, decryption of any information through any computer device. Only the central government has the power to issue directions for blocking for public access of any information through any computer resource. Which of these statements is or are correct? Let me know what is the right answer. Attempt to suicide has been decriminalized. MCOCA is Maharashtra Control of Organized Crime Act. Sir, we can't mention any IPC, CRPC sections in exams. What about advocates? They will learn. Special laws are not unconstitutional. Okay, the correct answer here is C. Both these statements are correct. We have Section 69 of Information Technology Act of 2000, and we have Section 69 capital A of Information Technology Act 2000. Under Section 69, both center as well as state government, what they have the power? They have the power that they can authorize their departments or authorize somebody to monitor online communications, to decrypt that information as well. That is the power that they have. But that is subject to the limitations under Article 19, Clause 2. The limitations are, you have the freedom of speech and expression, but that is not an absolute fundamental right. There are reasonable restrictions. That means in the name of security of the state, friendly relations with foreign states, sovereignty and integrity of India, incitement to an offense, on these grounds, your freedom of speech and expression can be restricted, which means central government and state governments, what they can do under Section 69, in the interest of the security of the state, in the interest of the sovereignty and integrity of India, in the interest of friendly relations with foreign countries, what they can do, they have the power to issue directions so that from any computer resource, any information which passes on, it can be intercepted, it can be monitored, it can be decrypted. But only the central government has the power. What it can do, it can block access. Block access in the sense, TikTok was banned. Close to 146 online betting platforms or money lending platforms have been banned recently. From which law does the central government derive the power to issue such a direction that this URL should be blocked, this website should be blocked, this YouTube video should be blocked? That comes under Section 69 capital A of Information Technology Act. And that again is subject to the restrictions under Article 19, Clause 2. That means the central government can do this in the interest of friendly relations with foreign states, in the interest of sovereignty and integrity of India. And whenever the central government issues this order, it has to issue this order in writing and mention why we are doing this. That's an important distinction that you'll have to make. And something else. Under the same law, Information Technology Intermediary Guidelines and Digital Media Ethics Code 2021 was issued. And this rule was notified in 2023. And under this rule, something else happened. And what happened? We have Press Information Bureau, which you must be reading, which you should read, because it's the publicity arm of the government. Any announcement, any communication that the government wants to make is done through PIB. And under PIB, a body was created known as Fact Check Unit. And what is this Fact Check Unit? The very purpose of this unit was to flag whether anything related to government business, to fact check any information that is related to government business, to flag it and label it as either false or misleading or fake. Even before 2023, the PIB's fact check unit was doing this. Important statement. Even before these rules were notified in 2023, or even before this fact check unit was giving power in 2023, the PIB's fact check unit was doing this. What it was doing? It was labeling any information related to government business as either fake, misleading, or false. What is misleading? For example, Al Jazeera published a news story saying Indian government has enacted a law which deprives Muslims of their citizenship. An anti-Muslim law was passed and enacted. Rules were made in 2024. This was flagged by fact-checked unit as misleading because Indian Muslims will not lose their citizenship under CAA. So that's a misleading statement. So it was flagged. And information can be labeled as false. For example, there is a bomb blast in Bengaluru. It didn't happen, but somebody is posting it. This fact check unit will label it as what? It is false. Or it can be fake. There was a bomb blast in Bengaluru. It did happen, but it was not because of IED, for example. It was because of an LPG cylinder had burst. But you're deliberately trying to give a sense that there was a bomb blast, there was a terror strike. So this fact check unit will label it as fake. That's the difference. But what this rule in 2023 did, it gave power to this fact check unit that any social media platform, that is what we call an intermediary. And what is this platform? For example, Facebook, for example, Twitter, for example, LinkedIn, for example, Instagram. Clear? Whatever you post on these platforms, will these platforms be held responsible for what you are posting? No. Why? Because that is what we call safe harbor. And what is this safe harbor? In the sense that if you are posting something on Twitter, Twitter cannot be held accountable for that because it's only an intermediary, it's only a platform. But if this fact check unit labels any Instagram reel or a YouTube short or a video or a Facebook post as false, misleading and fake, this social media intermediary has to take that content down. If you don't take that content down, then you will lose your safe harbor provision, which means you will be held criminally responsible for that. And 7 years imprisonment can be given to you. Somebody who is holding that position in that social media platform. Challenging this rule was one comedian, Kunal Kamra, who approached the Bombay High Court, and a 2-judge bench of the Bombay High Court gave a split verdict. One judge upheld these rules, other judge said this rule is blatantly unconstitutional. And now a third judge was appointed. Now this third judge has to decide whether these rules are constitutional or unconstitutional. But then the matter went to the Supreme Court. And what Supreme Court did? Supreme Court stayed this fact check unit, saying in an election time, it will have a chilling effect on the freedom of speech and expression. Because you criticize government, this fact check unit will label this statement or this tweet or this Facebook post as fake, false, misleading, and then the social media intermediary has to take it down, otherwise you will be held criminally liable for that. It will disturb the level playing field, and that is why it was stayed. But even if it was stayed, now there is a question for you. Rules were stayed, but CAA, when it was challenged as a law, it was not stayed. What's the difference between the two? And listen to me carefully. This is where there is something called presumption of constitutionality. Whenever a law, because law is passed by Parliament, representatives of the people, directly elected by the people. Whenever this law is passed, enacted by the Parliament, it is challenged before the court. The courts will presume that this law is constitutional. It is for somebody who has challenged this law. It is for this individual who has petitioned the court. It is for this individual to prove and convince the court that this law is unconstitutional. That means the burden of proof is on the petitioner. You have to convince the court that this law is unconstitutional. But that happens for a law. There is no presumption of constitutionality when it comes to the rules. So rules can be easily stayed by the courts. And that is why this fact check unit, which was part of the rules notified in 2023, was stayed immediately by the Supreme Court. So for rules, rules are different. For laws, rules are different, because for laws enacted by the Parliament, which is directly elected by the people, there is something called presumption of constitutionality. Clear? Yes, no, maybe? Okay. Question number 3. Consider the following statements regarding the sexual harassment of women at workplace, Prevention, Prohibition and Redressal Act and select the correct option. The central government maintains a centralized data regarding cases of harassment of women at workplaces. The law does not explicitly address instances of false or malicious complaint and false evidence. Which of these statements are correct? Let me know what is the right answer. How a constitutional bench can be less than 5-judge bench? It can't be. And I did not say that a constitutional bench is less than 5 judges. Let me know what is the right answer here. You have 30 seconds. Anurag, I am not ignoring, my dear. You tell me what is the question, I will answer. Taruna Chabra, definitely C should be locked. Okay, sir. I will lock D instead. The central government maintains a centralized data regarding cases of harassment of women at workplaces. This is incorrect because that is the response given by the Minister for Women and Child Development before the Lok Sabha, that we do not maintain a centralized database of all these complaints. The law does not explicitly address instances of false or malicious complaint and false evidence. It does. So that is why this is also incorrect. If a woman raises a malicious complaint, false complaint, or somebody gives a false evidence, there is a provision in the law. As per the company policy, action will be taken against that complainant. Clear? But why are we discussing this? This law, which is known as POSH, it was enacted by the Parliament in 2013, and it is based on the Vishaka guidelines of the Honorable Supreme Court. And these guidelines were put in place in the year 1997. And I think you would know the background. There was one Bamri Devi, she was gang raped in Rajasthan because she wanted to stop the marriage of a 1-year-old girl child. And basis that, there was a petition by an organization known as Vishaka, which wanted some protection in the form of preventing sexual harassment of women at workplaces. Guidelines were issued in 1997, and later on the law was enacted in the year 2013. And what this law does, it gives a very broad definition of workplace. So workplace is not only where you are working. Workplace can also be the transport that you are taking to reach that workplace. Workplace can also be you are sent on a deputation, you are sent to the field, you have to meet a client. Even that is a workplace. So workplace is not the confines of the organization. It can be the transport that you are taking to reach that workplace. That is how this workplace has been defined very broadly. Clear? That's number one. Number two, can you tell me, is this law gender neutral? Can both man as well as a woman raise an issue under this law? Because the law is clear, it's sexual harassment of women at workplaces. But listen to me carefully. Organizations, employers can make this law gender neutral. And there are organizations where this law is gender neutral. One such organization is this, where the law is gender neutral. And there is an obligation on the employer that every year you have to conduct workshops, awareness campaigns, so that all your employees are aware of this law. And that workshop or awareness campaign should also be conducted for POXO, Protection of Children from Sexual Offences Act. That's something that you'll have to keep in mind. That's number 2. Number 3, what this law does, every employer who employs more than 10 employees, what this employer has to do, it has to set up an internal complaints committee. This internal complaints committee need to have a woman who should head this internal complaints committee, 2 other women who are the employees of this organization, they should also be part of this committee. Other employee who can be a male as well should also be part of this internal complaint committee. And then somebody who is well versed, who has 5 years experience in, let's say, a non-governmental organization, that individual should be appointed as an external member. So whenever somebody is facing sexual harassment, and sexual harassment also has been defined very broadly, if your boss is making some unwelcome advances, saying you will get a promotion if you will do this, that's also sexual harassment. And whenever you face that problem, approach the internal complaints committee. The presence of the external member, the presence of these women, that will encourage these women to lodge these complaints. But why are we discussing this here? Close to 16 out of 30 national sports authorities in India, they have not set up internal complaints committee. So this is in response to the sexual harassment at World Wrestling Federation of India, where the MP was accused of sexual harassment by popular wrestlers and athletes, and no action was taken. Now a ticket has been given to his son to contest Lok Sabha elections, but that has got nothing to do with this complaint. This is just to set the context, and this can be an important statement. And the Supreme Court has come down heavily, saying there are 16 out of 30 sports federations in India which have not set up internal complaints committee. A majority of these internal complaints committee do not have an external member. But sir, what about those employers who employ less than 10 employees? For them, we have a local complaints committee, LCC. Which means a domestic maid, which means somebody who is from the unorganized sector, which means any other person or an establishment, a shop, which employs less than 10 people. If they have to register a complaint of sexual harassment, there is no internal complaints committee for them. They have to approach this local complaints committee, which should be set up in every district. And all these employers, they have a responsibility. One responsibility is to organize these workshops on a regular basis, create an awareness. And the other responsibility is that every year they have to submit an audit report. Audit report in the sense, how many complaints were registered and what is the action that you have taken against those complaints. That is what we need to know regarding this POSH Act, which is known as the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act. Clear? Sir, my question is, Supreme Court should quash special laws under the violation of Article 20. Please tell me why Supreme Court never quashes such acts. Because those acts still have some boundaries which they do not cross. For terrorism, unlawful activities, organized crimes, we have to have a special law, because the ordinary laws will not deal with them. So for the protection of the sovereignty, integrity of India, such laws are required. Okay. Let's look at question number 4. Which of the following statements is or are correct? India Justice Report ranks individual Indian states in relation to their capacity to deliver access to justice. It is released every year by Niti Aayog. The first report was released in 2019. Let me know what is the right answer. You have got 1 minute. Let me know what is the right answer. India Justice Report ranks individual Indian states in relation to their capacity to deliver access to justice. This statement is correct. States, big states, union territories, some union territories also, they are ranked whether they have enough police manpower, whether they are able to, whatever capacity they have, whether they are able to provide justice, deliver justice to the people, what is the concept of the legal aid. On these parameters, India Justice Report is released. It is released every year by Niti Aayog. This is incorrect because this is released by Tata Trusts. In 2017, Tata Trusts got an association with other organizations such as Common Cause, Tata Institute for Social Sciences, similarly Vidhi Center for Public Policy. All these centers, collaboration is done and together they prepare a report called India Justice Report. And the first report was released in 2019. So which of these statements are correct? B. Two statements are correct. B is the right answer. Marital rape is not an offense. Question number 5. The state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity and shall, in particular, provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Statement is, the above statement is an article under Part 4 of the Constitution. The article was inserted into the Constitution by the 42nd Constitutional Amendment Act. Project 39 capital A of the National Law University, Delhi is inspired by the above article. Which of these statements is or are correct? You have 1 minute. Let me know what is the right answer. Sir, this is out of topic, but can you explain the PYQ about finance bill and money bill? The key varies with Lakshmikant. Can you tell me what that question is? Paste that question, let me know. Madhvi says B. Okay. The above statement is an article under Part 4 of the Constitution. This is correct. Part 4 deals with directive principle of state policy. And this directive principle of state policy is Article 39 capital A, which was inserted by the 42nd Constitutional Amendment Act 1976, talking about legal aid. Free legal aid should be provided. National Law University, Delhi. There is a project there known as Project 39 capital A that is inspired by this. So all these statements are correct. C is the right answer. But sir, why are we discussing this? Because every year this Project 39A, it focuses on conversations related to death penalty, related to torture in the prison, related to prison reforms. And every year, this Project 39A releases a report. And the recently released report says on death penalty that the number of people on death row who has been sentenced to death sentence, capital punishment, it is highest in India since 2004. That is why there was a lot of conversations in the newspapers on this report saying majority of these convicts on death row, these belongs to the marginalized communities, Dalits, Adivasis, minorities. And then there was a lot of conversation on whether India should retain capital punishment as a form of punishment or not. So Project 39A is a widely discussed report that is released every year. And this is the question based on Project 39 capital A. Clear? What is the difference between martial law and national emergency? National emergency is imposed under Article 352 when the president is satisfied because of war or external aggression or armed rebellion. Then national emergency is imposed. Clear? But martial law has got nothing to do with national emergency. What is martial law basically? Number one, martial law has not been defined in the Constitution. What Constitution says, those people, those civil servants, those officers who have been tasked with maintenance of law and order when martial law is in place, after martial law is revoked, no action can be taken against them. So I was given a responsibility by the government that there is breakdown of law and order, there is armed insurgency, and that is why we are imposing martial law. Now your primary objective is to maintain peace. Whatever I will do, even if I violate fundamental rights during this period, during the period of martial law, no action can be taken against me. It will indemnify the public servant. But martial law has never been imposed in India. And martial law is not defined in the Constitution. And it has got nothing to do with national emergency. Question number 6, statement number 1. Rukmani Devi Arundale was the first woman nominated member of the Rajya Sabha. A vacancy in the nominated seat shall be filled within 6 months. And under the allocation of business rules, 1961, the subject nominations to the Rajya Sabha is allocated to the Ministry of Home Affairs, which is the administrative ministry for initiating the process of nominations. At the center, no nominated member has yet been included in the Council of Ministers. You have 1 minute. Answer this question. Article 34, it does talk about martial law, but it is not defining what martial law is. And it only says those servants, those employees, those people who are responsible for maintaining law and order, after martial law is revoked, they will not be held accountable for violating fundamental rights. What is the difference between if you have questions related to the topics that we are discussing, please ask. The doubts that you have on any other topic, let me clarify those doubts towards the end of the session. Rukmani, why this topic is important? Because Ms. Sudha Murthy has been nominated to Rajya Sabha. Because under the Constitution, the President can nominate 12 MPs to Rajya Sabha from the fields of art, literature, science, social service. And under the Constitution, governor can also nominate members to the Legislative Council. From these fields, art, literature, science, social service, but one more category, cooperative service. From the cooperative movement. Clear? So Rukmani Devi Arundale was the first woman to be nominated to Rajya Sabha. This is correct. She was nominated in 1952. A vacancy in the nominated seat shall be filled within 6 months. This is just to confuse you, because if there is a vacancy in any seat, whether it is Lok Sabha or Legislative Assembly, Election Commission has to fill that seat immediately, and within 6 months, or maximum within 6 months, it has to organize an election. But that does not apply to a nominated seat. So this is incorrect. Under the allocation of business rules, who will initiate this process of nomination? The ministry responsible for that is Ministry of Home Affairs. But ultimately, the final recommendation to the President comes from the Prime Minister. But how does the Prime Minister know that we have a vacancy in Rajya Sabha which we need to fill? For that, the ministry which will get in touch with the Prime Minister, which will be responsible for initiating this filling of nomination, is the Ministry of Home Affairs. At the center, this is correct. No nominated member yet has been included in the Council of Ministers, but that does not mean a nominated member cannot become a minister. There is no bar on that. You can become a minister. Clear? So which of these statements are correct? C, only 3 is the right answer. Clear? Okay. Question number 7. Which of the following statements is or are correct? In the first 2 general elections after independence, voters in some constituencies had to choose 2 instead of 1 MP. In India, there has never been a situation where voters in a constituency had elected 3 MPs. Candidates can contest elections from up to 2 seats only. Which of these statements is or are correct? Dr. S. J. Shankar was a nominated member. Was he not a minister? Dr. S. J. Shankar is a member of the Rajya Sabha, but he was not nominated to Rajya Sabha. He got elected to Rajya Sabha from Gujarat. In the first 2 general elections after independence, voters in some constituencies had to choose 2 instead of 1 MP. Correct. Because in some constituencies, you had to choose 2 MPs, 1 from the general category, 1 from the reserved category. There were at least 2 constituencies in Bengal where the voters had to choose 3 MPs, 1 from the general category, 1 from the Adivasis, the other from the scheduled castes. It was only after 2 general elections that all that was done away with. Now seats got reserved for SCs and STs in Lok Sabha. So in India, there has never been a situation where voters in a constituency had elected 3 MPs. This is incorrect because voters did. And candidates can contest elections from up to 2 seats only. This is according to Representation of the People Act 1951. This is correct. So only 2 statements are correct. B is the right answer. And in fact, there is also a reform suggested by various bodies, various institutions, which says it is like a torture to voters. Shri Rahul Gandhi contested from Wayanad. Once the voting was over, then he decided to contest from Raebareli, which may be, but you can't retain both the seats if you win. Which means if you win both the seats, you have to give up 1. And Mr. Modi did the same when he contested in 2014 from Varanasi and Vadodara. But he gave up Vadodara and retained Varanasi. and then in that constituency, election has to be conducted again. When election has to be conducted again, that means you are forcing the voters to vote again, which means like you are torturing the voter. And it is a waste of public money, public expenditure, public time. That is why even the Law Commission had recommended that we should amend Representation of the People Act, Section 77 of the Representation of the People Act, and only provide for elections in one seat. But that is something for mains exam. Question number 7, only 2 statements are correct. B is the right answer. Okay, question number 8. Which of the following statements is or are correct? All the 14 private members' bills passed in India since the enactment of the Constitution have originated in the Lok Sabha. The last private members' bill enacted in India was in 1996. The last 2.5 hours of a sitting on Friday shall be allotted for the transaction of private members' business. Which of these statements is or are correct? Again, I would request you, urge you, any other doubt that you have, apart from the concepts that we are discussing now, please keep them with you. We will discuss all these doubts towards the end of the session. And that is why today, the last 15 minutes, we will only take your doubts. Only your doubts. We will not discuss anything else. And tomorrow, the class that we will have, the live session that we will have, 7:30 p.m. onwards, we'll discuss up to 50 MCQs. So don't miss that class tomorrow. All the 14 private members' bills passed in India since the enactment of the Constitution have originated in Lok Sabha. This is incorrect. Yes, it is true that in India 14 private members' bills have been enacted, have been passed. And now there can be a question on your mind that, sir, what is a private member's bill? A bill which is introduced by a minister is a government bill. A bill which is introduced by a non-minister is a private member's bill. For example, a private member's bill was introduced recently from an MP from Punjab saying we should prevent the wastage of food and money in weddings. So we should impose a limit on the number of guests that can be invited to a wedding. It was a private member's bill. That means a bill which is introduced in the parliament by a non-minister becomes a private member's bill. For example, we have, let's say, as of now, Shri Varun Gandhi is the member of the parliament from Sultanpur constituency in UP in Lok Sabha. He's not been given ticket, so which means he won't be the Lok Sabha MP again, at least for the next Lok Sabha. But right now, he is the Lok Sabha MP. Any bill which he introduces also becomes a private member bill. Why? Because despite the fact that he is from the ruling party, he is from the BJP, but he's not a minister. Any bill introduced by a non-minister becomes a private member's bill. So don't confuse it saying a bill introduced by the opposition member becomes a private member's bill. A bill introduced by the member of the ruling party as well, even that becomes a private member's bill if that member is not a minister. Clear? 14 bills, private members' bills have been enacted. 9 of them originated in Lok Sabha. 5 of them originated in the Rajya Sabha. The last private members' bill enacted in India was in 1996. This is also incorrect. The last one which was enacted was in 1970. Which was, can anybody tell me what was that last bill? Enlargement of the criminal appellate jurisdiction of the Supreme Court. The last 2.5 hours of a sitting on Friday shall be allotted for the transaction of private members' business. This is correct. This is according to the rules of business and procedure. In any session, every Friday, the last 2.5 hours is to take up these private members' bills, resolutions, motions, so on and so forth. So A, only one statement is correct. A is the right answer. Clear? Question number 9. Which of the following statements regarding the National Human Rights Commission, NHRC, is or are correct? NHRC is a constitutional body. The chairperson of the NHRC has to be a former Chief Justice of India. The chairperson and members of the commission hold office for 3 years or till the age of 70. The members of the commission cannot be reappointed. Which of these statements is or are correct? How long will be tomorrow's session? You tell me, how long should it be? 1 minute, 2 minutes, 2 hours, 3 hours? NHRC is a constitutional body. National Human Rights Commission. Why? This is a very important topic for this year's examination. Global Alliance for National Human Rights Institutions has to decide what will be the rating of India's National Human Rights Commission. As of now, it is A. But if it falls to B, then India cannot vote in Human Rights Commission, United Nations Human Rights Commission. It cannot vote in some other United Nations General Assembly bodies. This revision happens every 5 years. And it was suspended for India in 2023. Now it will happen now, this year. And this Global Alliance of National Human Rights Institutions, it is a 120-member body. And it certifies the rating that is given to a country's National Human Rights Commission. The allegation against our National Human Rights Commission by this body is that there is too much government interference in this body. There is no religious and gender diversity. This National Human Rights Commission is under the control of the government. So it means it cannot independently implement human rights in India or investigate into human rights violations in India. And that is why this rating was postponed. Now it will happen this year. Dr. S.J. Shankar, our External Affairs Minister, is working hard so that India retains its A rating, because if we do not, the rating shifts to B, then we cannot vote in the United Nations Human Rights Commission and some other United Nations General Assembly bodies. That is why for this year, NHRC becomes an important topic. National Human Rights Commission, it is a statutory body. And what is a statutory body? A body which is created by the act of the Parliament, which is not there in the Constitution. And which act creates NHRC? Protection of Human Rights Act. This act was enacted in the year 1993. And this act is in line with Paris Principles, which want all the countries to uphold human rights in their respective countries. Clear? This NHRC consists of chairperson, and members. Significant changes were made to this NHRC in the year 2019. How? Previously, this chairperson had to be ex-Chief Justice of India, a former Chief Justice of India. 2019, when this law was amended, Protection of Human Rights Act was amended. Now the chairperson of this National Human Rights Commission can be ex-judge of the Supreme Court. And that's how Justice Arun Mishra, who retired from the Supreme Court, and immediately he was appointed as the chairperson of National Human Rights Commission. And that is why some people say that this law was changed because Justice Arun Mishra should become the National Human Rights Commission chairperson. Why? Because once, okay, that's not relevant for this exam, leave it. This law also talks about States Human Rights Commission. States Human Rights Commission, previously the head of the States Human Rights Commission should have been the ex-Chief Justice of a High Court. It was changed in 2019 to say that the chairperson can be the ex-judge of High Court, not necessarily ex-Chief Justice of a High Court. Clear? Previously, these members could have been reappointed, and reappointment could have been for 5 years. But now this law was changed, and this law allows reappointment. So this is a very important statement. This law, this amendment, it allows reappointment, but it does not mention that you can be reappointed for 5 years. Previously, you could have been reappointed for 5 years. Now you can be reappointed, but reappointed for 5 years, that is not clear. Clear? If we will have State Human Rights Commission, listen to me carefully. That means every state will have its own State Human Rights Commission under this law. What about union territories? The government can say that this particular state's Human Rights Commission will be the Human Rights Commission for this union territory. Clear? But for Delhi, the Human Rights Commission will be the National Human Rights Commission. Clear? Very good. Something else. There are 3 members who are also part of this National Human Rights Commission. And the law says at least one should be a woman. And then there are others who are called as ex officio members. Who are these ex officio members? Can anybody tell me? Chairperson of National Commission for Women, Chairperson of National Commission for Minorities, Chairperson of National Commission for Scheduled Castes, Chairperson of the National Commission for Scheduled Tribes, Chairperson of the National Commission for the Backward Classes, Chief Commissioner of Persons with Disabilities, and Chairperson of Protection of Child Rights Commission. All these will be the members. And the chairperson of the Protection of Child Rights, this will be the special invitee. That means he will be invited to the meetings. He is not a member. These are the other members, ex officio members. That means by virtue of me being the chairperson of the National Commission for Women, I will be the ex officio member of the National Human Rights Commission. Clear? So what does the question say? National Human Rights Commission is a constitutional body. This is incorrect because it's a statutory body. The chairperson of the NHRC has to be a former Chief Justice of India. No, you can be the judge of the Supreme Court as well, former judge of the Supreme Court, retired judge of the Supreme Court. This is also incorrect. The chairperson and members of commission hold office for 3 years or till the age of 70 years. Is it correct or incorrect? Yes, no. This is correct. The members of the commission cannot be reappointed, can be reappointed, But previously, they could have been reappointed for 5 years. That 5 year has been removed, but they can be reappointed. So which of these statements are correct? A. Only one statement is correct. That's the right answer. Clear? Sir, why was the last question in news? How will we know such implications of Parliament that when was the last private member's bill introduced? My dear, look at the previous year's question papers. That is why for this examination, there are two important sources that you must follow strictly. One is the syllabus. The other is previous year's question papers. Syllabus tells you what to study. Previous year's question papers tell you how to study. And what are the types of questions that have been asked previously? Office of Profit Act has been amended 3 times. Tell me whether this statement is correct or incorrect. So does that mean now you should know how many times a particular law has been amended? My dear, this is UPSC, Unpredictable Service Commission. You never know what will be asked in the exam. But since this topic is in the news, anything related to that topic, if you can know, much better, your chances of clearing prelims examination is much better. Okay? The year was 1914 when this Ingress into India Ordinance was promulgated. And your exam is in 2024, which means 100 years. These anniversary dates, they are very important. So if it's the 100th anniversary of Ingress into India Ordinance, and there is a link to this ordinance with something related to CAA, that is why this topic becomes important. This ordinance was promulgated in 1914 during First World War. And what was the intent of this ordinance? To screen, to detain, and to restrict the movement of those immigrants, particularly targeting Sikh immigrants who were coming from Canada. Why? Because a slogan was given by the Ghadar party, the Ghadarites, that we will launch a rebellion against the British rule in India. So the British government was threatened that these people coming from Canada, these Sikhs coming from Canada, they will launch a rebellion in India. That is why, according to this ordinance, we will screen all those who are coming to India. We will detain them. We will restrict their movement. That means we will take you to Punjab and we will not let you move out of Punjab. You stay there. That was the purpose of this ordinance. And this was for the first time used against those passengers who were coming from Komagata Maru. Yes, Vaishnavi is right. Komagata Maru ship incident, which docked in, it was basically Japanese vessel, which docked in Calcutta. More than 100 years, yes, 110 years. Similarly, POSH Act, which was enacted in 2013. It's been more than 10 years now, so that anniversary becomes important. Clear? Okay. Let's look at another topic, split in a political party. We have seen splits in political parties, whether it is NCP, whether it is Shiv Sena, and others. Who decides a split in a political party? Split in a political party? If this is Shiv Sena and there is a split, one camp is led by Shri Uddhav Thackeray, the other camp is led by Mr. Shinde. Who will get the name of this political party? Who will get the symbol of this political party? That is decided by the Election Commission of India. Now I will ask you a question. Does Election Commission of India decide on this split for all political parties? Yes or no? No, no, no. Then only those political parties which are against the BJP or against the ruling party. Only those which are the recognized political parties. So Election Commission of India gets to decide the split or takes a decision which faction is the real political party, who gets the name, who gets the symbol, if it's a recognized political party, and recognized as either state or national political party. But what about those political parties which are registered with the Election Commission of India? The Election Commission of India will tell that political party, if it's a registered political party, that if there are two camps and your political party has split, you deal with this on your own. You negotiate with each other and resolve this problem. And if you can't resolve this problem, go to the court, don't come to us, because we are here to resolve splits in a recognized political party, not in the registered political party. But how does this political party decide, how does the Election Commission of India decide this split? Who gets the real faction? Who is the real faction? By looking at the party constitution. What does the party constitution talk about? Does it mention that in case of a split, what will be the rules to be followed? What does the party constitution talk about the role and responsibility of the president of that party, the general secretary of the party? What does the party constitution talk about the office bearers? And then looking at the strength in the legislative wing and the strength in the organization wing. What do we mean by that? If Shiv Sena has split, how many members in the organization which are mentioned in the party constitution, whether it is the president or the district presidents or the office bearers, who supports, majority supports whom? Uddhav Thackeray faction or Shinde faction? That is one way in which it is decided. And second is in the legislative wing, all the MPs, MLAs, MLCs of Shiv Sena, majority supports whom? Whether Uddhav Thackeray or Mr. Eknath Shinde. That's how Election Commission decides. What if there is a tie? Or what if the Election Commission of India does not get to know which faction has the majority? In that case, Election Commission of India, what it does, it freezes the symbol of that political party, the name of that political party, and tells these factions, you have your own name, you have your own symbol, and we will give you the list of symbols. But if the Election Commission of India is able to decide based on what is the majority, who has the majority in the organization, in the legislative wing, then that particular faction gets the name and the symbol of that political party. But in case of the split in Shiv Sena, Election Commission of India got to decide only on the basis of the strength in the legislative wing. Why? Because Election Commission of India said the party constitution of Shiv Sena was changed in 2008. And the updated copy of that constitution was not shared with Election Commission of India. So we will not be able to decide on the basis of the organization who has the majority. And that is why we have decided this on the basis of the strength in the legislative wing. So 2-3 statements here very important. Statement number 1. The Election Commission of India resolves disputes when there is a split in a political party if that political party is a recognized political party. If it's a registered political party, then the Election Commission of India advises that political party to resolve their own disputes or approach the court. Clear? And when there was a split in Communist Party of India, when it split in 1964 into CPI, CPIM, that was decided by Election Commission of India. When there was a split in the Congress in the 1969, that was also decided by Election Commission of India like this. When there was a split in Shiv Sena or when there was a split in NCP, that was decided by Election Commission of India like this. Clear? And then if Election Commission of India is unable to decide or the two factions are unable to come up with the proof of who is the real faction, who is the real political party, in that case, the Election Commission of India freezes the symbol and asks these political factions to decide their own name, a different name and a different symbol. Clear? Clear. Political parties and the income tax. This is the last topic that we will discuss because it's 8:45 and I promised you that the last 15 minutes I will take your doubts. Whatever doubts you have, please feel free to ask. Do political parties have to pay income tax? Statement, is it correct, incorrect? Political parties need not pay income tax. They are 100% exempt from paying income tax. But what they have to do, they have to file ITR, which is what we call income tax return. And they have to submit this by 30th September in every financial year. And if they fail to submit this ITR within that time, then they have to pay income tax. So the issue with the Congress party was that they could not file the income tax return by that date, by 30th September of that financial year. That is why they have to pay tax. Otherwise, political parties are exempt from paying income tax. Clear? Now let me know what are your questions, and let me address all your questions one by one. And again, don't miss tomorrow's class because we're going to run a marathon. Is it explicitly mentioned? Yes, that is mentioned in 75 Clause 4, Election Conduct Rules, 1971, that in case of Lok Sabha elections, if there is equality of votes, returning officer will, through a draw of lot, pick one name, and it will be assumed that whichever name was picked, that person got an additional vote. But in case of Rajya Sabha election, whatever name was picked, that person has lost the election. Am I going to teach PSIR optional? No, my dear. What is the legislative wing? What is the organization wing? BJP is a political party. All the MPs of the BJP, all the MLAs of the BJP, all the MLCs of the BJP, they will be part of the legislature wing. But then there are others who are part of the organization, who are the general secretaries of the party, district presidents of the party, the vice presidents of the party, who are not legislators. They are part of the organization wing. Which restrictions were added to Article 19 later by an amendment? Public order, friendly relations with foreign countries, sovereignty and integrity of India, all these were added later on. Can martial law be imposed in the entire country? Yes. Decision of ECI is subject to judicial review? Yes, because judicial review is part of the basic structure of the Constitution. Can money bill be a private member's bill? Yes, but the condition is that before you introduce that bill, you need the prior sanction of the President of India. If the President gives you the permission, you can introduce that private member's bill. How Sachin Tendulkar was nominated to Rajya Sabha? Why? Because this list that you should be from art, literature, science, social service, this is only an illustrative list. This is not an exhaustive list. That means you can appoint anybody who has done spectacularly well in any field, and you can nominate that person to Rajya Sabha. What is the difference between a recognized political party and a registered political party? A recognized political party has the use of a symbol, gets free airtime on Doordarshan and All India Radio. They can have 40-star campaigners. Registered political parties can have only 20-star campaigners. There are lots of differences. New course coming for polity and governance? Yes, always. Every 2 months there is a new course. What is curative petition? We have discussed that yesterday. Presumption of constitutionality. When a law is passed by the Parliament and it is challenged before the court. For example, Citizenship Amendment Act was passed by the Parliament. It was challenged before the court. The court will assume that this law is constitutional. It's like you and your brother. You have fought with each other. And I'm your parent. I know he's a naughty guy. So I will assume that he would have provoked you into a fight. Now it is for him to prove and convince me that this time you instigated him, you initiated this fight. So that is why we say when a law is passed by the Parliament, it is challenged before the court will assume that this law is constitutional. It is for the petitioner to convince the court to prove that this law is unconstitutional. How MPs to Rajya Sabha are elected? MP to Rajya Sabha. They are elected by MLAs through a system of proportional representation system by means of single transferable vote through open ballot. How? Let's say, for example, for that there is a formula. Let's say, for example, there is a state. It has 3 vacancies. Clear? 3 vacancies are to be filled in Rajya Sabha. Because where is the composition mentioned? Schedule 4 talks about that this particular state will have 3 MPs to Rajya Sabha. For example, if the state has 300 MLAs, total number of MLAs divided by vacancies plus 1, which means 300 divided by 4 means 75, 75 plus 1 means 76. That means whoever gets 76 votes will be elected to Rajya Sabha. Which means if this 300 strength that we have in a legislative assembly, if out of 300 we have, let's say, 160 from BJP, we have 80 from Congress, then we have 60 from my political party, and there are only 3 vacancies. Any candidate who gets 76 votes will be the winner. Which means you will note that 2 MPs who will be elected to Rajya Sabha will be from the BJP and 1 will be from the Congress. Nobody from my political party, because I don't have 76 votes. Please elaborate on the bail provision of the PMLA after the latest amendment. In PMLA case, my dear, the courts can grant you bail if prima facie the court is convinced that you are not guilty and that you will not repeat the offense. For example, you are accused of committing theft. Clear? You are accused. Now the matter reaches me. You will give your evidence. The opposite party will give their evidence. And once I see the evidence, then I will come to know that you are not guilty. I will set you free. That means this term, whether you are guilty or innocent, that we come to know only at the end of the trial. At the end. But here the bail for PMLA becomes so difficult because the judge has to be convinced that you are not guilty. When will the judge be convinced that you are not guilty? When the trial is over. That is why it is very difficult in PMLA cases to be granted bail. Or when the judge is convinced that you won't repeat this offense. Who is that judge who will take it upon himself that I know Manish Sisodia will not repeat this offense again? That is why the bail is denied. That is why in PMLA cases we say the process becomes a punishment because the conviction rate is much less than 2% conviction rate. conviction rate, which means more than 98% of those who are accused of money laundering, they are acquitted by the courts. But the process is difficult because the bail is difficult. The number of questions. Okay, can you hold on to Ashok? Down, down. Yes, little up, little up. Down, down, down. This. In case Puttaswamy judgment, 9-judge bench, Supreme Court held that right to marry is an integral to privacy and dignity of an individual. How come a 5-judge bench of Suprio override 9-judge bench? In Puttaswamy case, the Supreme Court by a 9-0 majority said right to privacy is a fundamental right. Right to dignity is a fundamental right. What you wear, what you eat, what you drink, where you reside, these are intricate things about your privacy where the state cannot interfere, and these are integral part of your choices. Right to choice is your fundamental right. But the 5-judge bench in Suprio case clarified that that does not apply to marriage for homosexual couples. It is not a fundamental right. So right to privacy is a fundamental right. Right to have your own partner is a fundamental right. But marriage is something which is determined by society, according to Suprio judgment. Okay, you can scroll to the last. Can High Court review its own judgment? Yes, it can. Under Article 143, is it binding or not? Article 143 says, President of India can refer any matter to the Supreme Court, asking the views of the Supreme Court on that matter, asking the advice of the Supreme Court on that matter. And it is an advice. So advice is not binding. Advice is not binding. So technically advice is not binding. But then we say, if Supreme Court has given an advice and the government does not follow it and pass a law violating that advice, later on Supreme Court will strike down that law, because we know what we are going to rule on this matter. But if the question is asked in the examination, is the advice of the Supreme Court under Article 143 binding on the government, you can say no, because it's only an advice. Can Supreme Court review, little down. Can Supreme Court review basic structure judgment and strike that down? Yes, if a bench is constituted, more than 13 judges to review Keshavananda Bharati judgment, it can happen. In fact, in 2017, the judgment of 1976 was declared invalid by the court. The infamous judgment called ADM Jabalpur versus Shivakant Shukla, which is known as the habeas corpus case. That was declared bad in law by the Supreme Court in 2017. Advisory jurisdiction is taken from US. In United States, the president does not have the advisory jurisdiction. The Supreme Court there does not have the advisory jurisdiction. Sir, Election Commissioner Search Committee is headed by Cabinet Secretary, but you mistakenly told that is headed by Law Minister. Abhishek Patel, you are mistaken here. Maybe you have read the draft. So when the first draft was released by the government, when it was introduced in the Parliament, it was said that the Search Committee will be headed by the Cabinet Secretary. And the salaries of Chief Election Commissioner, election commissioners will be that of the Cabinet Secretary. But later on, when the bill was passed, it was specifically mentioned, the updated bill, that the salary of the Chief Election Commissioner and Election Commissioner will be that of the Judge of the Supreme Court, and the Search Committee will be headed by the Union Minister for Law and Justice, and not the Cabinet Secretary. Towards the end. Abetment to suicide is a crime. Yes. What is doctrine of severability? For example, here is a law. It has, let's say, 1, 2, 3, 4, 5 clauses, right? 4 clauses are in agreement with fundamental rights. 1 clause is not. Does that mean the entire law will be declared unconstitutional? Only that part will be declared unconstitutional. It's like there is something wrong with the hand of an individual. Does that mean you kill the entire individual or sever just the hand? You sever just the hand. That is what we call doctrine of severability. How MPs to Lok Sabha are elected in the same way as Rajya Sabha MP? Mr. A, you are a voter, so you will vote in this election to elect your MP to Lok Sabha. So the voter in this case is you. The voter in case of Rajya Sabha election is the MLA that you have sent to Legislative Assembly. That's the difference. So tenure of NHRC, you said 5 years. Tenure of the chairperson and members of NHRC is 3 years or 70 years, whatever is earlier. Sir, in the context of Sita Soren, at that point of time, Supreme Court has told bribery is allowed if they vote. So she used that judgment. How can she be punished retrospectively? She was not punished. How was she punished? Criticizing the judgment of the Supreme Court comes under contempt. If you are criticizing the Supreme Court on the basis of facts, if it is honest criticism, it is not contempt. Okay, that is it for today. See you tomorrow, 7:30 p.m. in the evening. We will have a marathon. We will have a marathon session on Indian Polity, and we will cover close to 50 MCQs tomorrow. So if you have missed today's class, which you haven't, others have, don't miss tomorrow's class. I'll see you tomorrow, 7:30 in the evening. Till then, have a great time. And before you leave, do not forget to press the like button. Do like this video. And once the video is over, drop in your comment as well. But not the comment in the live chat, because this live chat will get disabled. In the comment section itself, drop me your comments so that I can respond to those queries which I have not responded to right now. Thank you. Bye-bye. Good night. See you tomorrow. Stay safe.